2, 1.
Gentlemen, start your engines. Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, Civil Liberties will come to order. Without objection, the chair is authorized to declare recess of the subcommittee at any time. I welcome everyone to today's hearing on examining potential reforms of emergency powers. A very serious topic which we have explored in the past and will explore again. We have established an email address and distribution list dedicated to circulating exhibits and other written materials and motions that members might use today. Send them to the email address if you'd like to do so that we previously shared, and they will be distributed. Finally, all members and witnesses should mute their microphones when you're not speaking. This will help prevent feedback, other technical issues, and you saying things you don't want to have heard. You may unmute yourself at any time when you seek recognition. I'll now recognize myself for an opening statement. It was fitting that our first hearing under my chairmanship of this subcommittee, which was in February of 2019, was on the National Emergencies Act of 1976 and its implications for one of the core tenets of the Constitution's design, namely a governmental structure defined by checks and balances and the separation of power. Nothing more fundamental in our system. The specific impetus for that previous hearing was then President Trump's attempt to invoke emergency powers in order to divert billions of dollars in military construction funds to build a border wall. We heard a number of broader and bipartisan concerns about the National Emergencies Act and Congress's delegation of emergency authority to the executive. The National Emergencies Act was enacted in 1976 in order to constrain the use of presidential emergency authorities. Does not give the president any particular powers, but it sets forth the process that he has to follow if he declares an emergency in the process that we in Congress have to follow if we want the emergency to end. The Act sets out a procedural framework only and does not define what an emergency is. Congress passed the National Emergencies Act during a period of post-Watergate reforms after it became increasingly concerned that presidential emergency powers were becoming unwieldy and overextended. Before 1976, no statutory procedures existed for the presidential declaration of national emergency, and Congress had no defined supervisory role, checks and balances portion. It was a response to the abuses of the Nixon era that the Senate created the 1973 Special Committee on the Termination of the National Emergency, renamed the Special Committee on National Emergencies and Delegated Emergency Powers in 1974, which was co-chaired by the Honorable Senators Frank Church and Charles Mathias. The Special Committee issued its final report in 1976, emphasizing that emergency laws and procedures in the United States have been neglected for too long, and that Congress must pass the National Emergencies Act to end a potentially dangerous situation. It was against this backdrop that Congress passed that act in 1976. That was 48 years ago. Since that time, the National Emergencies Act shortcomings have come into view. For instance, one of the concerns we heard at our 2019 hearing about the limitations of the Act included the fact that there's little in the Act that would prevent presidents from renewing emergencies in perpetuity. The only mechanism that Congress has for ending an emergency without the support of the president is through a joint resolution of Congress, which requires the president's signature and is subject to a veto. The Act also does not require that any statutory powers invoked by a president relate to the nature of the emergency. In other words, the president can exercise numerous powers upon issuing an emergency declaration, even if those powers have nothing to do with the declared emergency. Exacerbating these concerns is the fact that, as many scholars and commentators point out, Congress has almost lost track of how many underlying laws exist that grant the president emergency authorities, or whether these grants of emergency authority remain warranted. Our witnesses will describe what some of those laws for us, many of which have never been used. Nonetheless, they remain on the books, and as Justice Robert Jackson put it in a famous dissent about a different claim of emergency authority, they, quote, lie about like a loaded weapon, unquote. In the 3 years since our previous hearing, members on both sides of the aisle and in both houses have introduced legislation to address the potential for a president to address these weapons. Broadly speaking, these measures would amend the National Emergencies Act to place more effective guardrails on a president's ability to invoke emergency powers and would reassert Congress's rightful place as a check on what would otherwise be almost unfettered executive authority. For example, Title V, Subtitle C of the Protecting Our Democracies Act would amend the National Emergencies Act to, among other things, empower Congress to proactively approve a presidentially declared national emergency. and require any national emergency declaration to expire after 20 legislative days absent congressional assent. It would also require that any emergency powers invoked by the President pursuant to a national emergency relate to the nature of and may be used only to address that emergency. Other proposals of note include the Article 1 Act, legislation introduced by Senators Mccleary and Representative Chip Roy, a member of our subcommittee, that would also amend the National Emergencies Act to place similar congressional guardrails in the President's exercise of emergency authority. While the House Judiciary Committee no longer has legislative jurisdiction over the National Emergencies Act, makes no sense to me whatsoever, but several things around here don't. It was this committee that helped in drafting the act. I believe the Judiciary Committee has a continuing obligation to ensure that the Act's purpose in seeking to restore proper congressional check on the executive branch is being met. The American people deserve our continued vigilance on this matter. They deserve to know the President cannot rewrite the law, exploit obscure loopholes in an effort to abuse power or even just exercise it unnecessarily. I look forward to the hearing from our witnesses today and bring a range of perspectives about the issues. I hope we can have a productive and fruitful discussion about whether we as Congress can do more to constrain these type of authorities so they're used only in true emergencies and not as an end run around the Constitution. I thank Mr. Mccleary for reinvigorating me on this subject and a group that he's chairing, and Ms. Goteen for returning to the country and continuing your pursuit of the truth. I now recognize the ranking member for his opening statement, Mr. Johnson of Louisiana, for his opening.
Thank you, Mr. Chairman. As noted, we actually have bipartisan agreement on the importance of this issue, and those are rare agreements these days, so really grateful for this hearing. Here's the Republican summary view. The National Emergencies Act is a principal framework, of course, through which the President exercises emergency authority. As noted, passed by Congress in 1976, the NEA was intended to rein in the President's use of emergency authority through various procedural requirements. But here's the thing that we all know, and I suspect there'll be broad agreement here today on this point, that the law has some shortcomings, let's put it that way. As we all know, the President can only act in our system, in our constitutional government, he can only act with the authority vested in him by the Constitution or specifically by Congress. The problem here is that Congress has been proven quite adept at delegating authority to the President over the years. And when Congress last accounted for emergency authorities delegated to the President in 1973, it found that more than 470 of such delegations had been given. In a report documenting these authorities, the Senate Special Committee on the Termination of National Emergency remarked that Congress had, quote, conferred enough authority to rule the country without reference to normal constitutional process, unquote. It's kind of an ominous summary there. Today, there are approximately 115 to 140 such delegations in effect, although, as the chairman said, it's difficult to count them sometimes, and it depends upon the source that you consult. Regardless of which number is correct, the presidents have proven to be proficient at declaring emergencies. There are currently more than 30 national emergencies in effect right now as we speak, with the oldest dating back to President Jimmy Carter. National emergencies are commonly renewed by the president, and the Congress rarely passes the joint resolution necessary to terminate them. So, although the NEA was intended to end perpetual states of emergency, it has actually resulted in presidents freely renewing emergencies, sometimes for decades. Of course, that seems to defy the common sense and the common definition of emergency, right? The NEA has proven to be an ineffective check on the president, and Congress has surrendered its authority to the executive branch for too long. We can't even say it was a usurpation of authority because Congress willingly gave it up. Article 1 of the Constitution vests all legislative authority in the Congress, and we are obliged to consider how to use that authority to more effectively control the president's use of emergency declarations. The way that political issues are framed today as existential threats incentivizes presidents to stretch the bounds of their emergency authority to accomplish policy goals, and sometimes partisan goals, that cannot pass the Congress. This is no way for our government to function. And in a moment when so many of our institutions are being imperiled and the people are losing faith in them, I think this is something meaningful that we could work on together and try to fix. Devil's in the details, of course, but that's why we're all here today. So I look forward to hearing from our witnesses, and I yield back.
Thank you, Mr. Johnson. Mr. Nadler's not going to be with us right now, and he wants his statement entered in the record, which he has given us, and without objection, it will be done. I understand Mr. Jordan does not have a statement, so at that point, we will proceed to go to our witnesses. We welcome our witnesses and thank them for participating in today's hearing. now introduce each of the witnesses, and after each introduction, we'll recognize that witness for his or her oral testimony. Each of your written statements entered into the record entirety. You have 5 minutes, and you know the 5-minute rule, the green lights, red, green, go, red, you're over, and yellow, you're in the last minute. Before proceeding with testimony, I'd like to remind all of our witnesses that you're under oath to tell the truth. We don't make you stand up and swear to anybody or anything. We just want you to know that if you don't tell the truth, you're going to be taken to the slammer. Our first witness is Ms. Elizabeth Goteen. Ms. Goteen co-directs the Brennan Center for Justice's Liberty and National Security Program and is a senior practitioner fellow at the University of Chicago Center for Effective Government. She's a nationally recognized expert on presidential emergency powers, government surveillance, and government secrecy. I think she cares about this as much as I care about the Memphis Grizzlies, which is a lot. She testified before the subcommittee in February of 2019 about the National Emergencies Act. Prior to joining the Brennan Center, she served as counsel to Senator Feingold, chairman of the Constitutional Subcommittee of the Senate Judiciary Committee, and a trial attorney in the Federal Programs Branch of the Civil Division of the Department of Justice. Received her law degree from Yale, law clerk to the Honorable Michael Daley Hawkins of the U.S. Court of Appeals to the Ninth Circuit. Welcome back, and you're recognized for 5 minutes.
Good morning, Chairman Cohen, Ranking Member Johnson, and members of the committee. Thank you for this opportunity to testify. The legal framework for emergency powers in this country is in urgent need of reform. It grants the president sweeping powers, some of which seem like the stuff of autocratic regimes with few safeguards against abuse. Fortunately, Congress has a ready way to build a meaningful check into the system. Let me back up and explain what emergency powers are and how they work. Emergency powers have existed in countries around the world for hundreds of years. The theory behind them is simple. Because emergencies are by definition unforeseen and unforeseeable, the powers conferred on the government by existing laws might not be sufficient to address them. But amending the law to provide greater powers might take too long and might do damage to principles that are held sacrosanct in ordinary times. Emergency powers thus authorize a limited departure from the legal norm. Their purpose is to give the president a temporary boost in power until the emergency passes or until there's time to change the law through the normal political process. Most countries have emergency powers written into their constitutions. Our Constitution is an outlier. It does not give the president any explicit emergency powers. And so presidents have, for the most part, relied on Congress to provide them. There are exceptions, and I hope we'll have time later in the hearing to talk about presidential claims of inherent emergency powers. In any event, for the past century, we have had a system in place where the president can declare a national emergency, and that declaration triggers special powers contained in a whole range of laws, all of which say something like, in a national emergency, the president can do X. For several decades, though, there was no overarching statute governing this system. Presidents didn't have to disclose what powers they were invoking, they didn't have to report to Congress, and there was no limit on how long emergency declarations could last. Congress passed the National Emergencies Act in 1976 to rein in presidential power. It attempted to do this in 3 main ways. First, it provided that emergency declarations would end after a year unless the president renewed them. Second, it allowed Congress at any time to terminate an emergency declaration using a legislative veto, a law that would go into effect without the president's signature. And third, it required Congress to meet every 6 months while an emergency was in effect to consider a vote on termination. By any measure, the National Emergencies Act has failed to achieve its purpose. Expiration of emergency declarations after 1 year, which was supposed to be the default, has become the rare exception. We actually have 41 national emergency declarations in place today, and most of them have been in place for over a decade. In 1983, the Supreme Court held that legislative vetoes are unconstitutional. So today, Congress effectively needs a 2/3 supermajority to end an emergency declaration over the president's likely veto. And finally, for more than 40 years, Congress simply ignored the requirement to periodically review existing emergencies. Why should this worry us? Because an emergency declaration unlocks powers contained in more than 120 statutory provisions, and some of these carry enormous potential for abuse. For instance, there's a law that allows the president to take over or shut down radio or wire communications facilities. It was last invoked during World War II, when wire communications meant telephone calls and telegrams, and most Americans didn't own a telephone. Today, it could arguably be used to assert control over US-based internet traffic. Other laws would allow the president to freeze Americans' assets with no judicial process, to coordinate and control domestic transportation, and even to suspend the prohibition on government testing of chemical and biological agents on unwitting human subjects. Given how potent these authorities are, it's remarkable that there hasn't been more abuse. We've been lucky, but it would be irresponsible to continue relying on luck and presidential self-restraint. Congress should pass legislation to restore its role as a meaningful check on these powers. There are several bills pending before Congress right now, broadly supported by Democrats and Republicans, that would require presidential emergency declarations to terminate after 30 days, unless approved by Congress using expedited procedures that would prevent obstructionism. This simple common sense measure would give presidents the powers they need when they most need them, flexibility in the immediate aftermath of a crisis, while still allowing Congress to step in and serve as a backstop against executive abuse and overreach. Thank you, and I look forward to your questions.
Thank you very much. Our next witness is Mr. Soren Dayton. Mr. Dayton is a policy advocate with Protect Democracy, previously worked at Hill and Knowlton Strategies. He's also worked on the late Senator John McCain's campaign for president and the campaigns of a variety of Republican candidates, among others. He's on the Board of Advisors of Tech Congress and was a Penn Kimball Fellow with the National Endowment for Democracy. AB from the University of Chicago, and you're recognized for 5 minutes, sir.
Thank you, Chairman Cohen and Ranking Member Johnson, for inviting me to discuss national emergency powers and opportunities for reform. I'm here on behalf of Protect Democracy, which works to strengthen our democratic institutions and separation of powers. Emergencies present a critical issue of checks and balances. In the constitutional balance of powers, Congress has the power to make laws and appropriate funds. The President has the power to implement laws and spend the money that Congress directs. In situations of national emergency, Congress rightly gives the President and the executive branch fairly broad leeway because of the need to act quickly and to make specific decisions. But that doesn't mean Congress wants to give the President unlimited power. Members of Congress, you, still want to say, and you have an important role in reviewing, supporting, or curtailing a president's execution of delegated powers. Congress found a solution 50 years ago in the National Emergencies Act. The NEA gave the president broad flexibility in emergency, but required clear reporting to Congress and empowered Congress to call a halt through a legislative veto. Any member of the House or the Senate could ask for a vote to block a president's action via concurrent resolution. That system was applied not just to national emergencies, but also to war powers and arms sales. But that system broke in 1983. The Supreme Court decision, INS v. Chadha, struck down the legislative veto that Congress had relied on to put a stop to emergencies when it felt the president had gone too far. Without that check, the delegation of emergency powers was transformed into something far broader than ever intended. It now requires a veto-proof majority in both chambers to override presidential action under emergency powers. Indeed, since Chadha, there have been virtually no checks on the president's national emergency powers. Typically, members of both parties complain about perceived abuses of executive powers by the president of a different party, and more recently, this has come to the fore with emergency powers. Yet, increased polarization and congressional gridlock have left those actions substantially unchallenged. Fortunately, there is a solution to restore proper balance of emergency powers. The key reforms are straightforward. The president must give a clear declaration of emergency, including which delegated authorities he plans to invoke. The authorities in the declaration would sunset automatically after a short period of time, and expedited procedures must be put in place to allow Congress to extend or terminate those authorities in a timely manner. Such reforms would closely model the intent of the 1976 National Emergencies Act. For many years, these important reforms lay out of reach, yet fortunately, Congress now seems ready to assert its rightful role regarding emergency declarations. Legislation encompassing these key changes now has broad bicameral and bipartisan support. My written testimony provides greater detail on the context for national emergency reforms and recent legislative efforts, but I will recap some of the recent milestones here. Last December, the House passed a strong reform of the national emergency system as part of the Protecting Our Democracy Act. That legislative proposal built on the work in a previous Congress, including a Republican proposal in the Senate that was marked up in committee in 2019. The House companion to that legislation was led by Mr. Roy on the subcommittee. In the Senate, over 30 Democrats have co-sponsored bills that include national emergency reform, and 20 Senate Republicans have either co-sponsored similar legislation or voted for it in committee. It's clear that there is strong bipartisan consensus on this important issue. We have the momentum to reclaim congressional authority in national emergencies. It's time to get it done. Thank you, Chairman Cohen, Ranking Member Johnson, for calling this hearing. I urge you all and the members here to translate that support into legislative action and pass national emergency reform this year. Thank you. I look forward to questions.
Thank you, Mr. Dayton. Our next witness is Mr. Giancarlo Canaparo, Senior Legal Fellow at the Heritage Foundation's Edwin Meese III Center for Legal and Judicial Studies. He researches, writes, speaks, testifies on regulatory policy, criminal justice policy, the federal courts, and constitutional law. His works have appeared in the Harvard Journal of Law and Public Policy, Notre Dame Law Review, the Administrative Law Review, and the Georgetown Law and Public Policy. Prior to joining the Heritage Foundation, he was in private practice and served as a law clerk for 2 years for a federal district court judge. Received his law degree from Georgetown and was editor of the Law Journal there. Received his bachelor's degree in economics from UC Davis. Mr. Canaparo, is it Canaparo right or Canaparo?
Canaparo.
Canaparo, you recognize for 5 minutes.
Thank you. Good morning, Chairman Cohen, Ranking Member Johnson, and distinguished members of the committee. The question facing the committee today is, how can Congress regain control over the executive branch's emergency powers? Over the years, Congress has gifted the president vast emergency powers that are at his command as soon as he issues the magic words, national emergency. He can redirect money, seize assets, suspend laws. Like two opposing pendulums, members of both political parties swing from celebrating this situation to opposing it and back again. But those with a longer view see the need to resolve this. They likewise appreciate that any limits that Congress imposes on the president's emergency powers are a double-edged sword. It will constrain a president of one party today and a president of another party tomorrow. But the status quo is also a double-edged sword, granting the president of one party today tremendous power and the president of another party tomorrow tremendous power. But the status quo suffers from the added side effects of being constitutionally suspect and ripe for abuse. Any set of rules is going to hurt one party and help the other, depending on who the president is. Wise leaders accept this and strive to create stability over time. The unwise, on the other hand, try to exploit the present broken system for short-term political gain. For those who are serious about repairing the present system, I offer a few solutions. I approach this starting from the Constitution's text and logic. The Constitution, by design, includes no emergency powers clause. The framers, as Justice Robert Jackson once observed, knew what emergencies were, knew the pressures they engender for authoritative action, and knew, too, how they afford a pretext for usurpation. Still, many parts of the Constitution do anticipate emergencies, the Army Clause, the Treaty Clause, the Guarantee Clause, and of course the Extraordinary Occasions Clause. But the theme that runs through them all is that Congress, not the president, is supposed to take the lead. This makes good sense because if the president gets extra powers whenever he decides there's an emergency, you might reasonably worry that he'll go find some useful emergencies. The potential for abuse is there. Congress, unfortunately, has created it, but Congress can fix it. As I set out in more detail in my written testimony, I offer a few solutions. My solutions are substantive, not procedural, for a couple of reasons. As my co-witness here mentioned, the procedural limitations are effectively cut off by the Supreme Court's decision in INS versus Chadha. But procedural solutions were always going to be second-best solutions anyway. They don't realign us with the underlying constitutional logic. And as long as that partisan pendulum continues to swing, Congress is likely to exercise oversight functions of presidential emergency power only when it's controlled by the opposite party. So instead, Congress should impose substantive limitations on the president's emergency powers. To put it simply, to paraphrase my mother, you brought these powers into the world and you can take them out again. But how do you establish a framework to do that? The Constitution provides the guide. It anticipates that Congress will take the lead in addressing emergencies. So generally, Congress should do so. Now, that's not to say that Congress should give the president no emergency powers, but that Congress should give him such powers only when it is convinced that it is incapable of reacting with necessary speed. Now, I think this will be a high bar because in the past, when the country has faced serious crises, whether it was the attack on Pearl Harbor or 9/11, Congress has reacted with tremendous speed. With that in mind, your first step should be to reevaluate all of those laws that give the president emergency powers and eliminate all but those you believe require a speedier reaction than Congress can deliver. The second solution is to impose a time limit on all emergencies, not longer than 2 years. 2 years because the Constitution's Army Clause says that Congress must renew the Army's funding every 2 years without exception. It doesn't matter if the country is invaded by a hostile force, the Army's funding will run out without Congress's action. If the response to an invasion ends after 2 years without congressional action, then no other emergency need last longer. A third solution is to give the president temporary emergency powers on a case-by-case basis at his request. Rather than create a vast array of powers that the president can activate whenever he sees fit, make him come hat in hand, so to speak, to you to ask for specific powers narrowly tailored to the crisis. Again, I provide more detail in my written questions, but my written statement, but in the meantime, I welcome your questions and I stop there.
Thank you, sir. Final witness is Mr. Joel Mccleary. He's managing partner of Four Seasons Ventures, which has conducted in-depth studies for the Department of Defense and the Department of Homeland Security on biodefense. These studies reviewed emergency powers of the president in the event of a pandemic or major biological weapons attack. He's also co-founder of the organization Keep Our Republic, a nonpartisan civic action organization dedicated to protecting a republic of laws and strengthening the checks and balances of our democratic electoral system, although he's testifying today in his personal capacity. Mr. Mccleary works on issues related to presidential emergency powers with former Ambassador William G. Miller, who was staff director of the Senate Special Committee on National Emergencies, previously served as Deputy Assistant to the President during the Carter administration, and accordingly with President Carter. He's a graduate of Harvard University, and he's recognized for 5 minutes. Thank you.
Chairman Cohen, Ranking Member Johnson, and distinguished members of the subcommittee, thank you for this opportunity to testify today. I think it's important in this busy town to take a deep breath sometimes and drink in the moment that we're in. And really, today is a historical moment. After 50 years, this committee is going to return to an issue that this Congress tried to struggle with, the nation tried to struggle with, and was unable to resolve. What provoked the first real analysis of this issue 50 years ago were three giants, Republican giants of the Senate, Senator Baker, Chuck Mathias, and Senator Cooper, who were extremely worried about the assumption of powers that President Johnson was taking in the administration of the war and in the suppression of the anti-war movement and the work that he was doing with J. Edgar Hoover. So what's important about the discussion is the origin of the discussion was basically bipartisan. And it was in fact driven by the Republican Party, by the giants of the Republican Party who were worried at that time period about these extraordinary powers. And in that context, I would like to talk for a second about how I got introduced to the first part of the issue, and then deal with how Miller and others tried to deal with it in the Congress. My first introduction to the issue was as a young and very insignificant member of the White House staff. I was asked to go to Nelson Rockefeller's funeral. And we went up on Air Force One, and I was sitting at the table with Judge Bell, Brzezinski, and Carter. My only role really was to carry bags. But I got to overhear a conversation that's taken me 30 or 40 years to really understand. And that conversation is important to understand in terms of the powers that a president must have and must assume. And then, of course, the second part of the conversation is how do we balance those powers that that president must have. And the conversation I overheard that day was Brzezinski and Carter talking about his option. And by the way, the person sitting next to us was the gentleman carrying the nuclear suitcase. And Carter asked Brzezinski how he could buy more minutes before he destroyed the planet and launched thousands of nuclear weapons. And what he didn't want to do was to follow the plan that had so appalled President Kennedy when he was first introduced to this, was the idea of launching within probably 8-9 millions, 3,000 or 4,000 nuclear weapons and destroying life as we know on the Earth. And so Carter had asked whether we could have a phased-in escalation so we could determine if there had been an accident or if there was some way that we could work with the Soviets to scale back. And from that became a document called PD-59, which in itself became very controversial because Carter and Brzezinski maybe overstepped or controversially overstepped their powers in determining what the nuclear policy would be, and they kept tremendous secrecy around it, which is still discussed today. But after that conversation, for years, I thought about how do you ensure that the president has that freedom, and how do we make sure that it is not encumbered. When I left the plane that day, I drove into the funeral with Judge Bell, who was then Attorney General. And he was a wonderful old man from Georgia. And he said, "Son, do you understand what you just heard?" And I said, "I'm so happy I heard it." And he said, "Well, you better think about that for a long time." And he said, "But you understand what it means for an assistant to the president for political affairs if such an event were to unfold?" And I said, "What's that?" He says, "You're irrelevant." So, because we're going to enter into a whole other new world. Later on, my first cousin was Bill Miller, who was the man that was asked to come back to Washington by Senator Cooper, by Senator Mathias, to deal with these issues. I know I'm running out of time. But
Your time's extended, for such time as you may consume.
Okay. So Miller was brought back to work with the Republican giants of the Senate to figure out how they could contain Johnson's powers and then, of course, Nixon's powers. And he was instrumental in writing the legislation that we're discussing today. Shortly before he died in 2019, he called myself and Mark Medish, who is my co-founder of Keep Our Republic, and he said, "I want you guys to write me an op-ed for the New York Times or the Washington Post on the failure of our work 50 years ago, and to not only articulate why that legislation failed, but the issues we must now address." And we promised to do that, and he died before we had the opportunity to do it, but he also asked us to pick up this flag or this mission and work to try to deal with this issue, and that was the origin of Keep Our Republic, which is a bipartisan organization that is trying to put together the kind of coalition that we had at that time period 50 years ago. Days before he died, he told me, and I will close with this, "Joel, you're focusing on the statutory powers and how to use that vehicle to deal with the abuse that can occur with the president." And he said that is essential, and it's very essential that that record be complete and that you pass this legislation, but you have to understand at the end of the day, it probably will not work. But it's important to have that record for the courts to see when they make final deliberations about the inherent powers of the president. And I'd like to close with that. To get this legislation passed, or to get these reforms in place in a bipartisan way, is absolutely essential, but it is just the first step of the task ahead of us. And what I would, in closing, ask that the committee really focus in the next step, and we start wrestling with these whole issues of inherent powers without ever restricting those powers that our president needs in the kinds of crises that President Putin is reminding us of every day these days. Sorry for the extra time, Mr. Chairman.
Thank you, Mr. Mccleary, and thank you for your time and your work. There are a couple of articles I'd like to introduce into the record without objection. One is a treatise by Miss Linda Green, a professor of laws, called Up Against the Wall, Congressional Retention of the Spending Powers in Times of Emergency. Without objection, it will be introduced. And then secondly, there is a letter from a bipartisan group, National Taxpayers Union, Americans for Prosperity, Concerned Veterans for America, Freedom Works, R Street Institute, Taxpayer Protection Alliance, Taxpayers for Common Sense, rather bipartisan group, with a one-page letter simply asking for support for efforts to reform the act. And so without objection, that will be entered in the record as well. I did mention in my opening that we do not have direct jurisdiction over these laws. I knew that. I asked again my counsel, Mr. Park, why. Apparently in the early 1990s, the parliamentarian ruled that it goes to transportation. That parliamentarian is gone, but as Congress continues, just like with the National Emergency Act, that work and that decision lingers. And it was because, as I understand it, there was a national emergency issued concerning a transportation issue. So he ruled on the particular bill without ruling on the concept, which was stupid. But we still are burdened by that. So we're going to put in a piece. The council says you can change the rules. I guess you can change the rules now. Does it take 2/3? Well, we'll put in a rule change and try to get it changed with 2/3 and have them directed to the judiciary, which it should be, and we'll try to change that. But that's something we're laboring under. Mr. DeFazio, I have a lot of appreciation for, and I think he's right about Boeing not moving to Virginia, but he doesn't probably give a hoot about this or even know what's in his jurisdiction. With that, we'll go to questions. I will be first, and I will proceed under the 5-minute rule with questions. Ms. Goteen, you mentioned that there's certain inherent powers that presidents sometimes claim. What are those inherent powers that they sometimes claim?
Thank you for that question. And let me just quickly point out that Congressman DeFazio has actually sponsored National Emergencies Act reform in the National Security Reforms and Accountability Act, and is.
Well, don't tell anybody else that I said that.
Well, he's a strong champion on this issue. So I hope that the two of you will be working together. I am very worried about claims to presidential claims to inherent constitutional emergency powers. As I mentioned before, the Constitution does not give the president any explicit powers, and the handful of powers that it does include that look like crisis response powers are granted to Congress, not the president, and John Carlo covered that in his testimony. Nonetheless, that has not stopped administrations, in the last few decades anyway, from laying claim to vast inherent emergency powers, and these claims are very often set forth in secret Department of Justice legal memoranda that we only know about when they happen to be leaked, such as in the case of the torture memos, as an example. These claims cannot be tested because there is no way to get them in front of a court, and they have not been validated by the courts, but they are lying there like loaded guns. And one of the reasons why this concerns me so much is because of the existence of a category of emergency powers known as presidential emergency action documents. These documents are draft executive orders, proclamations, directives, messages to Congress that are prepared in anticipation of a range of worst-case scenarios, ready for the president's signature if one of those scenarios were to come to pass. They originated as part of the Eisenhower administration's planning for continuity of government in the wake of a Soviet nuclear attack, but they've since expanded to address other types of emergencies. These documents are almost completely shrouded in secrecy. None of them has ever been released or even leaked. Moreover, they are not shared with Congress, despite the fact that even the most highly classified covert military and intelligence operations have to be shared by law with at least the Gang of Eight. Nonetheless, we do know a little bit about their contents from other official records, Department of Justice memoranda and the like that have been made public over the years. And from these sources, we know that emergency action documents up to about 1970 purported to authorize martial law, suspension of habeas corpus by the president, the roundup and detention of subversives inside the United States, and censorship of the news media. Presumably, at least some of these proposed actions rested on claims of inherent emergency powers because there were no statutes in place at the time that would have permitted them. We know a lot less, frighteningly, about the contents of current emergency action documents. But we do know that as of 2017, there were 56 of them, and they were undergoing review and revision by the Trump Department of Justice. Now, I want to be very clear, there is nothing wrong with advanced planning for emergencies. It's a good idea. That's not the problem here. The problem is twofold. First, at least some of the older documents that we know about had plans in them that would violate the Constitution or laws passed by Congress. And second, and perhaps relatedly, Congress is being cut out of the planning process, and that prevents Congress from exercising its constitutionally assigned oversight role. It also allows the president to rely on secret claims of inherent authority that have never been tested or approved by any court. Senator Ed sorry.
Let me ask you this. I can't Google emergency powers and they'll all come up. Is there there's no place in the world where you can just go and look them up in the back of a book and go, emergency powers, and they'll show up?
You cannot see any presidential emergency action documents. The Brennan Center has a resource page that has compiled all the publicly available documents that refer to them, that describe them, in order to try to get a sense of what's in them. But the documents themselves, you cannot find them anywhere. They have never, ever been disclosed in any way, shape, or form.
Did the 1976 law require them to expire after 1 year?
No, it did not apply to presidential emergency action documents. Now, let me say that these documents are planned actions. So they are directives that are not signed yet. And the idea is if an emergency were to happen, they would be put into place. It's possible that some of these documents, some of these directives, would trigger emergency powers under the National Emergencies Act that then would expire after a year. My concern is that some of them rely on claims of inherent presidential authority that would not fall under the National Emergencies Act. And
Thank you.
Sorry.
Go ahead.
I wanted to quickly say that Senator Ed Markey has a bill that would address this problem in the simplest and most tailored way possible. It would require the president to disclose presidential emergency action documents to the relevant oversight committees in Congress. And that legislation has been incorporated into the Protecting Our Democracy Act, which has passed the House, and also the bipartisan National Security Reforms and Accountability Act.
Thank you. Mr. Johnson, you're recognized in 5 minutes or more.
Thank you, Mr. Chairman. Appreciate the insight of our witnesses today, really do. It's really important, and thanks for the history lesson, Mr. Mccleary. We could listen to you all morning. My questions are for Mr. Canaparo. Congress passed the National Emergencies Act, as we've all discussed, to try to place guardrails around the president's use of emergency authority. So not to crash the bipartisan mood of the hearing here, but I've got to talk about current real-life events, right? So some on the left right now as we speak are calling on President Biden to use this authority to circumvent Congress and to accomplish radical political agendas. So, for example, just last January, 2021, Senate Majority Leader Chuck Schumer said that President Biden should declare a national emergency to address climate change. Obviously, this is something I believe Congress should be deliberating. President Biden should declare a national emergency on other things. Last few weeks, White House scrambled to hold meetings to determine how it can declare a national emergency in the wake of the Dobbs case leak regarding keeping abortion on demand in place. So the question is kind of a broad one. Would declaring a national emergency to address climate change, for example, be an abuse of the president's emergency authority? What do you think about it?
So I'll take a slightly unusual tack. It reminds me of, I don't know if you're familiar with the author James Freeman Clarke. He wrote, politicians look to the success of their party, statesmen look to the success of their country. Politicians take a 4-year view and try to achieve whatever they can with whatever power they have in 4 years. Statesmen take a 100-year view. And so the question really is, who should decide? If you find yourself cheering on the president's use of emergency power when you agree with the outcome and decrying it when you don't, you might fall into the politician camp and not the statesman camp. The question is who decides, and the answer that the Constitution provides is Congress. Congress should decide, except when I think it is fair to say you all decide, Congress decides that that there are some situations in which you truly cannot react with the necessary speed. But I'm going to quote from a law review article by then Professor, now Justice Amy Coney Barrett, that keeping these sorts of decisions in the legislative branch ensures that the decision to suspend or to activate emergency powers emerges from a process that is relatively more representative of the people whose civil liberties are at stake. So when we get into the problem of deciding, of looking at specific emergencies, what we're trying to do is reason from specific examples that we like or don't like into a general framework. But that's not how we're going to solve the problem. It is much better to start from the Constitution's text and logic and reason forward into a general framework that we can all live with, whether we like the outcomes or don't.
I love that response. And Justice Amy Coney Barrett has been a dear friend of mine since high school. And back then in the 80s, we used to talk about concepts like this. We were the two nerds in the room. But there was a lot more statesmanship at the time, right? And not, and maybe less politicians. Quoted, going back to your earlier statement. And this is the quandary, the situation we find ourselves in, right? Not enough people are taking the national perspective and the long view. We're all trying to achieve these immediate gains. And I think it's corrosive to the institutions, and I suspect, well, I know you all agree. Let me ask you, if for those of us who have to make some ultimate decisions on this, what would you say is the best source of the original intent? Particularly, we're talking a lot about inherent emergency powers and that kind of thing. What's some of the best source material we can go study from the founders' view? Is it the Federalist Papers? Is it particular sources? What would you say on that? I might ask all of y'all that question.
Sure. Just to keep my answer short, my sort of go-to is often Justice Joseph Story's commentaries on the Constitution of the United States.
Perfect. That's great. I've got that volume. How about Ms. Goteen? I never.
Goteen.
Goteen. Okay.
Yes.
I thought it was French. Sorry.
So I think there are a number of sources in Giancarlo's testimony that are absolutely worth looking at, and I would add, these are a little more recent, but I would add Justice Jackson's opinion in Youngstown, I think is a seminal articulation of the balance of power between the president and Congress, and for looking at sort of the intent of the framers and sort of an originalist understanding. There's a wonderful article by Professor Sai Krishna Prakash at the University of Virginia Law School entitled The Imbecilic Executive. I love that title.
Yes, I wish I'd chosen it myself.
It's not quite as ad hominem as it sounds, and it's a truly wonderful article, and I would recommend it to everyone. And it shows how our understanding of inherent presidential authority has just morphed dramatically in recent times from the original understanding, which was that the Congress did not provide the president with any inherent emergency powers.
And the reason is, I'm out of time, but I'll just conclude by saying this. Obviously, we're going to original intent, talking about the framers' intent. They wanted a full body of the duly elected representatives of the people to make these important decisions, as you indicated, and not just one person. And that was that is inherent in our system, is that we're trying to dilute and separate the powers, and this is maybe the most glaring example we have of the abuses and the usurpation. So appreciate all your insight. It gives us a lot to think about. I yield back.
Thank you, sir. Interesting to know about you and Justice Barrett's longtime relationship. Mr. Canapar, is it John Carlo?
John Carlo, yes.
So that was a second mistake I made. The first one I got your name right, but thank you. Ms. Ross, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to the witnesses. This has been a fascinating hearing. In 1976, Congress formalized the ability of the executive to exercise emergency powers during times of national duress. And you've given us a great history of how that's operated. But throughout this pandemic, we've seen the president and governors of states across the country use these powers to respond swiftly to a rapidly evolving public health crisis by expediting the production and delivery of personal protective equipment, implementing mask and vaccine requirements, and issuing shelter-in-place advisories for at-risk communities. We must remember that this authority is not inherent to the executive. Rather, it is a privilege that exists through an act of law passed by Congress. The ability to frame and limit the power of the executive ultimately belongs to the people. And that's why we're here discussing this important topic. I strongly believe that our nation ought to grant emergency powers in times of crisis. But what we must be diligent in ensuring that such powers are not abused by the executive. Emergency authorities must only be exercised at times when science and public safety indicate that foregoing the legislative process is critical to protecting the lives and health of Americans who are at immediate risk of harm. We've seen such scenarios in the past, such as during natural catastrophes, wars, and right now, a public health crisis. In each of these instances, there's a clear and imminent threat to the safety of the public. This ought to be the standard that we follow when determining whether it's appropriate to grant emergency authorities to the executive. My first question is for Ms. Goteen. I hope I said that right. How can Congress increase transparency in how presidents are actually using their emergency powers?
Thank you, Congresswoman. That's a wonderful question. The bills that we are talking about, including the Article 1 Act, the Protecting Our Democracy Act, the National Security Powers Act, all of these bills would require enhanced reporting. Right now, under the National Emergencies Act, the president only needs to report on expenditures that have been expenditures in relation to emergency declarations every 6 months. And frankly, it is not clear that this is even happening. We've been unable to track down reports of the expenditures related to the 9/11 emergency declaration, for example. So first of all, Congress needs to insist on getting the reports it should be getting under existing law, but under the reforms that we are talking about, the president would not only have to report on expenditures, but would also have to report on the specific actions that had been taken within the reporting period, and I think that's very important. May I say one quick thing also about the COVID emergency declaration, which is actually, it's interesting, very little of the federal response to COVID-19 has relied on powers available under the National Emergencies Act. National emergency powers are really a very small part of that, and actually, for all of the actions that are currently relying on the National Emergency Declaration, there are non-emergency powers that would allow the president to do the same thing. Mostly the laws that have been undergirding the federal response have been, for example, with the mask mandate, that's the Public Health Service Act, and it's a provision of the act that's available without any emergency declaration. And similarly, in terms of spurring production of vaccines, that was under the Defense Production Act, most of which is available to the president without any emergency declaration. So yes, I agree, it's important to move flexibly and quickly. It was important when COVID struck, and it remains important that there be flexibility in the provision of healthcare services and similar actions. That flexibility is available under a wide range of laws, and very little of it right now is dependent on the National Emergency Declaration.
Thank you so much, and I yield back.
Thank you, Ms. Ross. Now, patiently waiting, but I'm sure with great questions and insight, Mr. McClintock.
Well, thank you, Mr. Chairman. I want to thank you for a truly nonpartisan hearing on a very, very important subject. James Madison said that, in his opinion, the single most important provision in the Constitution was a provision that gave the power to declare war to Congress and not to the president. And the reason for that was simply that war enhances the power of the president enormously, and therefore it creates an obvious perverse incentive if the president is to declare war. It follows that any measure that enhances the president's power should not be in the hands of the president, human beings being what we are. We kind of, in the words of the great philosopher Jack Handy, in a former life I must have been a great king because I really like it when people do what I tell them to. That's just in our nature. There was a discussion at the convention with respect to the wording of that clause. It was originally giving Congress the power to make war solely, and that was changed from make to declare for concern that the president should have some power inherent to repel an immediate invasion before Congress could make a declaration. December 7th, 1941, the Japanese attacked the U.S. fleet at Pearl Harbor. December 8th, 1941, the president appears before a joint session of the Congress. In that speech, he says, "As Commander-in-Chief of the Army and the Navy, I have directed that all measures be taken for our defense." FDR understood that beyond those immediate acts, he could not take any offensive act without the declaration of war by the Congress, which was then forthcoming. The reason I recount all of this is to ask, is there any conceivable occasion, other than a surprise attack, where the president should be able to invoke extraordinary powers without the consent of Congress? Oh, I'll start with Mr. Mr.
Conaparo.
Thank you.
My name tag has disappeared, so I apologize for that. So I am generally skeptical of the argument that the president has inherent powers that are beyond those articulated by Article 2. I think you hit the discussion about the attack on Pearl Harbor sort of illustrates how this is supposed to go. Certainly, as Commander-in-Chief of the Armed Forces, the president has certain powers attendant to that constitutional directive. The power to, for instance, defend the country from an invasion or a hostile attack is certainly inherent in his role as Commander-in-Chief, but that's
and
not
very limited to repelling an attack, not initiating an attack on his own. My question is there any circumstance, conceivable circumstance, where the president should be able to invoke powers on his own authority?
powers separate from these attendant to being Commander-in-Chief?
Well, I'm speaking more broadly of any a pandemic, for example. Why would the president be given authority to acquire extraordinary powers on his own say without the consent of Congress? It seems to me that that is the proper role of the decision-making branch of the United States government.
Thank you. In general, yes. The problem we're operating from right now, though, is that over the last 100 years or so, Congress has delegated to him so much power.
Yes, well, maybe
already.
we should try to undelegate all of those powers. My question is there any conceivable circumstance, I'll throw it open to any of the panelists, where the president should have that authority?
I would argue that we have to look at the circumstance. The president wouldn't even have to ask for the authorities. He would just assume, I use the term assumed inherent powers. So let's take real world cases.
Well, I mean, the president can assume the power to stop the tide from coming in, but that doesn't make it right or,
I understand
or realistic.
that.
Yeah, I mean, it doesn't give it any authority.
But my point is, and Miller's point was that the president will act regardless of whether you give him authority or not, and that is the problem. It's often said that the president has two.
Well, doesn't the Constitution prevent that? I mean, the Constitution is a separation of powers. It's mother's rule writ large. Mother has two hungry sons, one slice of pie. How does mother slice the pie so both of them are satisfied? One slices, the other chooses. That's the constitutional separation of powers. One brother appropriates funds but can't spend them. The other spends funds but can't appropriate them. One brother makes law but can't enforce it. The other enforces law but cannot make it. One brother can declare war but can't wage it. The other can wage war but not declare it. That's a self-correcting mechanism. I'm out of time now, but it seems to me that it is time that Congress restored that balance, which is at the center of the constitutional architecture that keeps us free and keeps the Constitution self-enforcing. Again, there's no penalty for violating the Constitution because the Constitution is supposed to be a self-enforcing document. And the only way that works is if the separation of powers is maintained. We've blurred that separation of powers and I think put at risk the entire architecture of our Constitution. I yield back.
Benjamin Franklin had a very cryptic remark to that. He said there are only two ways that you can actually control a president, and that's either to impeach him or assassinate him. And this is the problem when you get into, let's say, a biological attack, is where I looked at it, and also a nuclear attack. Events move so quickly. If a normal event, we can go through this process. But what happens, given the circumstances that we were talking about with President Carr at the beginning, where we have 15 or 20 minutes to make decisions, or let's say a smallpox attack hits, and we have to make decisions almost instantly about who gets inoculated and who doesn't get inoculated, all these kinds of things, that's when we get into this very dangerous territory.
Thank you. I just quickly wanted to jump in on what Mr. Mccleary was saying and say that it may be the case in some situations where presidents are going to act on the spur of the moment very quickly, and it may be a situation where they think it's an existential threat, and they're not necessarily going to limit themselves to what the law says or what the Constitution says. What used to happen in this country, and Professor Prakash discusses this in his article when that happened, is the president would act, but he would acknowledge that he had acted in haste and perhaps outside the bounds of the Constitution in order to try to preserve the nation, and he would go to Congress to try to get some kind of ratification for that. He would not pretend that his actions had been authorized by the Constitution. What happens today is that presidents assume that anything that they think is necessary for the preservation of the nation must therefore be authorized under Article 2. It doesn't work that way. And I think the system we had in place earlier, where the limitations of the Constitution were acknowledged, and where if a president stepped outside the bounds, everyone acknowledged that the president stepped outside the bounds. If it was considered in retrospect to be something that was beneficial for the nation, Congress would step in and ratify it, would pass legislation indemnifying the actors, for example. But to say anything that in the moment the president feels that he or she must do, by definition is therefore constitutional, that's backwards and it's very dangerous.
Thank you very much. Mr. Johnson, you're recognized for 5 minutes.
Hey, all right, thank you, Mr. Chairman. I've got some people doing some work, some heavy construction work on the outside of my apartment, which I have no control over. And I think it creates a very inconvenient, aggravating situation for the witnesses. So what I will do is I will yield my remaining time to you.
Thank you and good luck. I want to now recognize a man who we have awaited his arrival. He's timed it well. Our honored guest, our most noted member for dealing on this issue in the past, the gentleman from Texas and the University of Virginia, Mr. Roy.
Well, I appreciate the chairman and really do appreciate this hearing and appreciate the witness, appreciate you all being here. This is an important issue, and as was noted earlier, I believe, my friend Mccleary in the Senate and I worked together to introduce this legislation, the Article 1 Act, in the previous Congress, my first Congress. And I would note when President Trump was president, and I would note it was in response to some degree, and much to the chagrin of some of my supporters back home, with respect to the building defense along the border and the use of emergency power to go down that road. And I'm a strong supporter of needing infrastructure, as is well noted in debates in this committee, and believing that we need a fence and a wall and we need to have infrastructure in the border, in the southern border, to manage that crisis. But I believe in limits to executive power. And I think it's critically important that we do that. And to the point of Mr. Canapano, the reality of politicians kind of flapping in the breeze, I think, a little bit on this, sort of based on the political expediency of the moment of whatever issue you want to accomplish, is a real risk for all of us, both sides of the aisle, no matter who's in power. And that we ought to, this body, find ways to come together to try to constrain the executive within the appropriate lanes under the Constitution, and reassert congressional authority where it's necessary. So the bill is obviously designed to rein in these 40, I think you testified 41, I think I had 43 from CRS, but whatever it is, 40-some emergencies that we're operating on dating back to 1979. It's just patently absurd that we'd be operating under a, quote, emergency for almost as long as I've been alive. I mean, that's an extraordinary reality that we're dealing with. I did want to note, and then I want to throw to some questions to you all, in the current context, and like my friend from Louisiana mentioned, I don't want to break down in a bipartisan feel here. I actually mean this with respect to both President Trump and President Biden. But I'm deeply concerned about the use of emergency powers during this pandemic. Deeply concerned. Not because of the motives involved, not because of whatever disagreements we might have on how power should be, or on the effectiveness of vaccines or so forth, but just literally the power of the government through saying, and by the way, not just through the National Emergencies Act, right, but through the Stafford Act, through the Public Health Service Act, and other powers granted to the executive branch, that we have a situation where the President of the United States can declare an emergency 700 and whatever days ago it was, 792 days ago, and then have that extended by a subsequent president, and then use these acts and have the power of the president and the executive branch say, okay, we've got this problem, this emergency, and under that have the ability for pharmaceutical companies, whether it's Operation Warp Speed to try to get it done, or whether it's the extension under the Biden administration to try to encourage people to take it, to then have liability protection for those companies with a mandate from the government under the auspices of an emergency that people then get said vaccine, and then potentially through the coercion of the power of government say you might lose your job if you don't take said vaccine, if you're in the military and so forth, or a federal worker, Border Patrol, FBI, anybody else, healthcare worker. The extraordinary power of the executive branch doing all that I just said without a single act of Congress to say, yes, go do that. Would the panelists agree that that is a concerning use of emergency power and authority by the executive branch? If you could go quickly, because I got 40 seconds and I'll sum up, go down the line. Yes or no, roughly?
I'll give you 70 seconds.
Okay, well, thank you, sir.
I'll be very quick. I think that when COVID struck, it was absolutely an emergency. It met the definition. I think broad flexibility for the president and for the federal government was appropriate. I think the question is, where are we now, 2 years after the pandemic? And is there a way to transition now to non-emergency powers? And if the non-emergency powers in place are not sufficient, whether Congress can step in and provide the
Mr.
necessary
Dayton,
authority.
thank you. Ms.
I agree with Ms. Goteen's comments. I think a critical part of any reform is going to be providing for a way for Congress to act quickly, and I think that's, your bill does that. Obviously, the Protecting Our Democracy Act components on national emergency reform do that. And I think that could be a foundation for building this in other areas. And we've mentioned the National Security Reform Accountability Act as a model that uses this in war powers and arms sales to foreign areas, but you could also think about ways to use this domestically. But I think this is an opportunity to sort of build a foundation, an example that you can use in other areas.
Mr. Canaparo?
Yes, so what you hit on is this problem with the national emergency laws, the whole panoply of them, creates such a draconian and arcane system that these decisions can be made and the ripple effects can ripple outwards without any say-so from Congress and without any input from the people. So the problem really is one of this who decides problem, and it's certainly at this point, because of the way that Congress has delegated so much power, it's not you anymore, and it should be you.
Mr. Mccleary, and thanks, Mr. Chairman, for the indulgence.
This is the nut of the problem, and I totally agree with you, and I totally agree with the ranking member that this is the struggle, is to restore the balances of power. President Trump actually made a very intelligent statement that was rather disparaged when he said, you know, I have powers you do not even know about. And that was a great contribution because it opened up this whole discussion, in fact. And you need to move in this legislation that we were talking and achieve the objective that you're talking about. But then we also need to explore, again, what President Trump had introduced, and that is, what are these powers that no one knows about? And they are dictatorial. The fact is, the President of the United States has two powers. One, to blow up the world, President Carter, and the second is, with not even a stroke of the pen, blow up the Constitution. And we've got to, as the ranking member points, in our role in saving the Republic, to keep the Republic, we have got to wrestle with these questions. And this is the historic moment to do that. So I really applaud the work that you've been doing, Congressman.
Well, I appreciate y'all. Mr. Chairman, thank you for the time. And I would just note for the committee, for our work as a Constitution subcommittee on a bipartisan basis, that, and I mean this truly, my concern here spans across both presidents from both parties. And the pandemic is a good example because there's an altruistic motive to care for people and ensure that there's a vaccine available and that people can get, and we've had debates about that. But the point here is just the power. Like, who gets to decide? How does that happen? And the importance of congressional action on that. Anyway, I appreciate the extra time from the chairman.
Thank you. Let me ask, the legislation has been introduced. Mr. Roy and Mr. Lee, does anybody here not think that's a law that should be passed? Everybody thinks that's a good bill. Okay. You don't think it was a good bill?
I think it's a great bill, but
good.
he's sitting right here. He's sitting right here, you can be honest.
Thank you.
I can leave if you want to be able to speak freely, Mike.
And if I could add to that, that bill has served as the core reform in all of these other bills that we've been talking about. Some of those other bills have added some features. For example, several of them would add a 5-year total limitation on the length that any emergency declaration can stay in place. I think some of those additions were helpful and are definitely worth looking at.
Now, that bill hasn't become law, though, right?
Correct. None of this
And
has
is it
become law.
because
We're
it
so
was,
close.
is it a standalone or is it part of another bill now?
Well, so the Article 1 Act is still standalone, but then there are pieces of it, as the gentlelady was talking about, that it goes that have been embedded into other reforms that have been put forward.
In fact, in its entirety, pretty much, that bill was picked up and put into several other pieces of legislation, and along the way, other features were added, and I think it's worth looking at some of those other features.
Yeah.
I'm sorry.
Well, you need to let, no, I mean,
We'll get to you in a minute. I didn't see you, Ms. Jackson-Lee, but we'll get right to you. But we're going to finish up this discussion quickly, if you don't mind. So there were some bills that were put in the Democracy Act, right?
Protecting Our Democracy Act, yes. And that started essentially with the Article 1 Act, and it includes a 5-year limitation on the total length of any emergency declaration. It also includes a limitation on using emergency powers to deal with anything other than the emergency, so that the powers have to relate to the nature of the emergency, as you were speaking about in your opening statement. And it has a provision that emergency powers cannot be used to take an action that Congress has expressly withheld authorization for.
All right, and how about Mr. DeFazio's proposal? Is that's something that,
Very similar to what came out of the Protecting Our Democracy Act as it passed the House.
right, so the Protecting Our Democracy Act, it turns out to be kind of a problem because it's not going, it's dead. So it's taking with it down to the bottom of the sea some good things that might be able to pass.
Well, I mean, the Protecting Our Democracy Act has many different provisions in it. The NEA reform provision within the Protecting Our Democracy Act has, as we've mentioned, extremely broad partisan support. So maybe
Those
that
need to
piece
be
of it-
extracted from the law and made a freestanding bill, and maybe they'd have to see the light of day. Thank you.
Mr. Chairman, may I ask one quick follow-up question? Mike, or Senator Lee and I, we directed this obviously with very specifically to the National Emergencies Act, I think, but should we expand that to apply, or at least in concept, to the other bills or other acts I mentioned, like the Stafford Act or the Public Health, Public Health Service Act, or other things where there's extensive use of executive power?
I think it should be a longer process, I think, of looking at those acts and how they've been used to try to figure out the best solution for them. I would hesitate to say right now that that's the right solution for those bills. I think they address different issues and work differently. They have different existing procedural
That's fair.
criteria in place. So I don't know that it's that simple. It's worth taking a look.
Can I add one thing before we go to the great Sheila Jackson Lee? Just one thing, Mr. Chairman, briefly on that, because it's so important. The Stafford Act, of course, covers natural disaster, hurricane emergency declarations, and just one parenthetical note. On day 30, sometimes they're just getting on the ground to assess the needs and all of that. And so I think that's a totally different calculation, but I yield back.
Yeah,
Thank you.
and just
Ms. Jackson Lee, you're recognized for 5 minutes.
Good morning. Let me thank the witnesses for their, I think, very detailed expression. I think we'll look very deeply at their statements, their written statements. I want to follow the line of questioning of my colleagues in terms of what I heard, the different aspects of declarations of emergency. And anywhere living in hurricane country, anywhere from the desperation of those of us who are experiencing hurricanes, and we are begging for a declaration of emergency, if you will, sometimes stymied by our state governments not acting quickly. There may be other national, if you will, weather disasters. There's the medical disasters, and of course, there is the question of issues dealing with national security. Let me refer the witnesses back to January 6th and the early denials from the 2020 election that there was a victory for Joe Biden, but there was a victory for someone else, the prior president. And the text that we have about potential of martial law, which is a little different from the issue of national emergencies. But I'd appreciate if each of you witnesses would answer the question about how careful we need to be in discerning between medical emergencies, which may need to go on for a long time, versus someone who abuses it in a question that may impact national security. I think changing elections impact national security. So what kind of fine line do we need to make sure a president can act when Americans are desperate, as opposed to a president using it to overturn elections, to engage in conflict or war outside of declaration of war? So would each of you, starting with Ms. Goteen, answer that question, please? Thank you very much. And Mr. Mccleary, Ms. Dayton.
Thank you, Congresswoman. I think Congress can and has made that distinction on its own in certain cases. And as an example, I will mention the Public Health Service Act and the provision of that act that allows the CDC to make regulations to prevent the transmission of communicable diseases into the United States from other countries or between states. That authority is not an emergency power. And that's because when Congress granted that authority, it knew that this was not the kind of thing that could be where the president needed to do something for a week and then might not need to do that after a week, that a communicable communicable disease, that's hard to say, that is spreading across the country. That is a process. And Congress wanted the federal government to have in place the authority it needed throughout that process to try to limit the spread of that disease. So I think Congress itself can distinguish between powers that are going to be needed in the long term. Most legislation doesn't have a limit on how long the president can use those authorities, right? I mean, sometimes there are sunsets, but often it is indefinite. So Congress can make that distinction. Now, for things like martial law, the Brennan Center has a report on this. We don't actually think martial law is legal. We don't think the president has any authority under existing law to declare martial law. So another important piece of this, especially when you're looking at some of the discussions around January 6th, is to separate out the real emergency powers from the imagined ones.
Thank you. Mr. Mccleary?
I think it would be very advantageous to perhaps if former Governor Ridge were able to testify. He's had a stroke, but he had to struggle with a lot of these issues. And over at Homeland Security, a lot of these PEDs exist, and they deal with all these issues of domestic crisis. And that's why, and maybe Ms. Goteen can comment on this, it is important that in any legislation that's put forward, that you get insight to the Office of Legal Counsel's rulings on these PEDs. And are they using Second Amendment authorities, or are they using statutory authorities, or both in assuming these actions? But Congresswoman, I think you would find it most interesting to have Homeland Security or the Secretary, if you have the jurisdiction, to really try to define what their position is on all these actions having to do with domestic crisis, whether it be a disease, or whether it be a hurricane or whatever, because they're there and they have struggled with this issue. But again, right now it's secret. Thank you.
And Ms. Dayton?
Thank you for the question. I think there's two important
Mr.
parts
Dayton,
of my
I'm sorry.
response here. The first part is that we should be talking about clear authorities. So the talk about martial law, as Ms. Goteen has pointed out, there is no actual statute that would allow the president to invoke martial law via an emergency framework. That said, there are a lot of things lying around in the U.S. Code that are somewhat scary, and there should be a careful review of those and probably a substantial pruning of those powers.
Thank you. Thank you.
Let me just thank you so very much, and let me say that this is work that we must do. Thank you. I yield back.
Thank you, Ms. Jackson-Lee. We have, I think, had a very good bipartisan hearing. Hopefully we can get some work done out of it. I appreciate the witnesses for your testimony, which has been so invaluable in your work. This concludes today's hearing, and I want to thank you all. Without objection, all members have 5 legislative days to submit additional written questions for the witnesses or material for the record. With that, the meeting is adjourned.